things, it is this Narcotic Drugs and Psychotropic Substances Act of 1985. Done? Shall we move ahead? Now, this particular operation name that your DRI had taken for anti-narcotic initiative. Anti-narcotics means they are psychotropic substances. Narcotics means psychotropic substances. Anything that puts you in a hallucinated stage, or anything that gives you a fog in the brain where you cannot think straight. Okay? So, the Directorate of Revenue Intelligence had created an anti-narcotic initiative that was called as Operation Weed Out. We'll move ahead. Now, a small brief about Directorate of Revenue Intelligence. See, this will become important is because 2025 ka prelims pe, they had asked your directorates, bodies and which concerned ministry they belong to. Your Directorate of Revenue Intelligence was established in 1957. It was under Central Board of Indirect Taxes and Customs, otherwise under Ministry of Finance. Directorate of Revenue Intelligence is coming under Ministry of Finance. Usually very high probability of getting you confused with this is putting it as Directorate of that is Ministry of Home Affairs. Okay, so it will not come under Ministry of Home Affairs, it will come under Ministry of Finance. And with regarding to any smuggling, okay, this is the apex body for anti-smuggling in India. Done? So, what are the functions of Directorate of Revenue Intelligence? As of now, prevent drug trafficking, wildlife and environmental contraband. That is, you cannot, let's say, people have this wildlife trafficking, skin, bones, customs duty evasion and trade-based money laundering. All of this comes under the ambit of DRI. It also enforces Customs Act and 50 other allied acts, indicating that if it is anything with regard to illegal take of your plants, animals, wildlife, narcotics or even money laundering, all of it will come under your DRI. And they will be dealing with multiple things, Arms Act, Narcotics Control. Basically, in this broad category, what and all acts are made, all those acts will give them power. Recently, other operation apart from Operation Weed Out they tried was Operation Fire Trail. Okay, Operation Fire Trail was to crack down on illegal Chinese fireworks. Now you may think, okay, this Operation Weed Out, something it dealt with high profile thing, that is narcotics. Why are they banning fireworks from China? This is a very important thing because your Chinese fireworks are relatively cheaper. Okay, and they are not manufactured according to your Indian standards. And most importantly, what happens is during many a times, even just storing the fireworks. Now, if we all have shops, until we go buy that firework, light it on fire, it won't. But from China ka fireworks, what we saw was even just storing the fireworks in one place, it automatically started bursting. If one small thing happens like that to a firework, imagine to a firework shop and the subsequent shops. So everything was getting caught on fire, which was leading to huge loss of lives and human threat. Because of that, they had a crackdown on illegal Chinese firework also under the name of Operation Fire Trail. So these two are the operations. One is for narcotics, one is for fireworks. Now the act, just because we introduced that act, we will see a little bit on the act. Narcotic Drugs and Psychotropic Substances Act of 1985, wherein this is the act which regulates and prohibits production, possession, sale, transport and even consumption. See, up until here there is no issue. It will be very easier in the statement kind of question. Regulate, prohibit, production, possession, sale, transport. But this act ka speciality is even consumption of narcotic and psychotropic substances are banned by this act. Understanding? So this becomes the most important thing there. Consumption of narcotic and psychotropic substances. Shall we move ahead? What are the exceptions of this act and what agencies are related to this? If at all there is anything that you are going to make, okay, apart from medical and scientific purposes, and that too which has to be operating under a government issued license, no other thing can be made. Many a times it was, you would have seen newspapers, people who were having rented house, in that they found 1 kg of narcotics, 2 kgs of narcotics, plant growing under their bed. All of this is illegal. Implementing agencies are 3 in order to deal with narcotics. Narcotics Control Bureau, your Directorate of Revenue Intelligence and State Police Department. All 3 have the authority to deal with narcotics. Done? So we'll see a possible question. I will read out all the options. You tell me which is right or wrong. With reference to Operation Weed Out, consider the following statements. It was launched by Narcotics Control Bureau to curb drug trafficking across Indo-Myanmar border. What is it?
It's not MCQs.
Yes. And it was not to traffic across, or it was not dealing with any specific border zone. The issue they can convert statements like this was, we told it was caught in this particular flight route. That didn't mean that it is dealing with Indo-Myanmar border. Okay. The operation targeted, and also it was not by Narcotics Control Bureau, it was by Directorate of Revenue Intelligence. So this is also not correct. The operation targeted smuggling of hydroponic cannabis which is cultivated without soil. This is correct. Hydroponic itself means no soil. The Directorate of Revenue Intelligence functions under Ministry of Home Affairs. Very good. This is under Ministry of Finance. So the correct statement is only 2. Next topic is Amul ranks as world's top cooperative in GDP per capita. Done? Why was this in news? Recently, Amul was ranked as world's #1 cooperative. Okay, this was told by which particular International Cooperative Association and World Cooperative Monitor 2025. What are cooperatives, especially your Amul, known for? Inclusive growth, rural empowerment and cooperative success model. Nothing important as of here comes, but look at this. Gujarat Cooperative Milk Marketing Federation, okay, which was founded in 1973. This was the one that led to your creation of Amul and Amulka products. It's headquartered at Anand in your Gujarat. Okay. So this is what created your Amul, or this is what created your White Revolution or Operation Flood. Like Green Revolution, something like your dairy products ka revolution was created under your Operation Flood, or your White Revolution also is what we call it. That was brought about by your Gujarat Cooperative Milk Marketing Federation with its line of products under the name Amul. Okay, your Amul, from now on what will reference, it is a 3-tier cooperative model, which means village level, district level and state level. Three-tier pe village level, district level, state level. Because of this, a lot of farmers ke liye additional incentive was also added, because your farming is not a 365-degree activity. And also many women came into your workforce, because it is let's say women conventionally in a patriarchal society do not own any land. Now for them this became a place where they could earn money. They could not own lands, but they could own your animals. Yes, and also government started giving loans even for that also. So through that, women empowerment started happening on a greater basis. Initially the idea was to create additional incentive for farmers, but this was another boon for your women empowerment. As of now, your Amul has more than 36 lakh milk producers across 18,600 village cooperatives. The data is not very important. Now about your International Cooperative Alliance. Now these are the people who are telling that yes, this Amul is ranked as the first one. This is founded in headquarters of Brussels in Belgium. International Cooperative Alliance, this becomes important because UNP each year will be designated for a particular thing. This year 2025 is year of cooperatives. Because of that, this body becomes important because it is dealing with cooperative alliances. It looks after the cooperatives of entire world. Its headquarters is in Brussels, which is in Belgium. It was founded in 1895. It is the apex body promoting cooperative principles and also sustainable development practices. We'll move ahead. This, that is your International Cooperative Alliance and World Cooperative Monitor. Both these are the ones which gave the report putting your Amul in the first place. Your combined exercise of International Cooperative Alliance and URIS, that is European Research Institute on Cooperative and Social Enterprises, conducted a study where they found a trial where all the cooperatives of the world, if you take the highest contributor from both your economic as well as social perspective. See, economic means just trying to increase in your GDP. But this Amul not only increased economy but also gave more social contribution. How social contribution? In the form of women empowerment, social inclusion, equity. In these aspects, it gave a bigger contribution. This was measured through your GDP. This was measured through your societal indicators. So, what are cooperatives? If you see, they are voluntary, democratic and member driven. Key word here for your cooperatives is one member, one vote. Each of them has equal amount of weightage in a cooperative society. In India, it started around your 19th century so as to curb your rural indebtedness, and also if all of these people pool their money together, come up with one particular business plan, they can run their own business. Rather than if each one person comes up with the idea, each person will try to go to a money lender and they being cheated upon. So because of this, your cooperatives are brought in and recognized by the government. What are the key legislations? If you see, it is Cooperative Societies Act. This is important, write down key legislation in cooperatives. Cooperative Societies Act of 1912. The second one, cooperative credit societies, means bodies which will give money or lend money to the cooperatives. The first one is very important. Cooperative Societies Act of 1912. We'll move ahead. We will see constitutionally what is the recognition for cooperatives. First and foremost, 97th Constitutional Amendment gave a legal status wherein your cooperatives are now added under Article 19(1) of C, which is right to form cooperatives, and also it inserted Part 9B into the Constitution, that is from Articles 243ZH to 243ZT will all be speaking about cooperatives, and also it added for Article 43B to the DPSP wherein it wants the state to promote cooperatives in their respective state. So 97th Constitutional Amendment legalized the recognition for cooperatives. We'll move ahead. These are the recent changes that has been brought in. There's also a Supreme Court issue, I'll tell you. See, your state cooperatives has been added. Now if I take cooperatives, this is just one word. The issue comes is cooperatives is in your 7th schedule pe we have lists. Union list, state list, concurrent list. Union list only center will make laws, state list only center will make laws. Concurrent list pe both center and state will make laws. Your cooperatives are present in 2 lists. Under your multi-state cooperatives, which means, let's take Amul. Even though it is present in one state, its branches are in all the states. It can create its branches in other states also. So one particular state it might be registered, but it might be running its operations in multiple states. Thus the name multi-state cooperatives. This is coming under your union list. Understanding? Just the cooperatives, if you are going to set it up in your own state, are under state list. Now when your center created 97th constitutional amendment, the states were complaining that 97th constitutional amendment, for them to do, they should have got state ratification, because it is something in the state list. They never took it, so we will not legally consider your 97th constitutional amendment, is what states told. Center told, why should I need half of the ratification from states? It is already in my list itself. So this issue was taken in front of judiciary. Finally, judiciary decided whatever changes that was made under your 97th constitutional amendment and further changes it will make, it will be applicable to multi-state cooperatives and not just state-based cooperatives. Within the state only it is there. It is not going to branch out anywhere in the respective other states, means then that provisions will not apply here. This is what judiciary's present day ruling is. Center had created, in order to deal with all the multi-state cooperatives, it created the Act, Multi-State Cooperative Societies Act of 2002. Multi-State Cooperative Societies Act of 2002. Okay. Initially, cooperatives was mixed with Ministry of Agriculture. In 2021, they carved out something called as all the cooperative topics will now be dealt by a separate dedicated ministry called Ministry of Cooperatives. So, Ministry of Cooperation was created in 2021. 2021 onwards, anything with respect to cooperatives will be looked after by Ministry of Cooperation. Before that, it was under Ministry of Agriculture. Okay, this 2002 Act, Multi-State Cooperative Societies, was amended in 2023 to increase more transparency and accountability. This was amended for increasing accountability and transparency in cooperatives. So, how many cooperatives, if you see, we have? Total we have 8.42 lakh cooperatives in India, of which contributes 27% of the world's total cooperatives. Top cooperatives are your Amul, and in the state wise, if you see, top 5 which are having very good amount of cooperatives means Maharashtra, Gujarat, Telangana, Madhya Pradesh and Karnataka. We'll move ahead. So, recent one is National Cooperation Policy was added in 2025. Look at this. This is only a policy. It is not an act. Now, this particular policy, whatever 2002 once they had created, when they created Multi-State Cooperative Societies Act, when they created, they also created one policy in 2002. Now, in 2025, when they have brought this policy, this will be for dealing with cooperatives from 2005 to 2045 period, that how cooperatives should be working. Like how we had NEP 2020, there is one cooperative policies in 2025. The mandate of this particular policy was Sahakar se Samriddhi, prosperity through cooperation. This mandate is very important. Sahakar se Samriddhi. What are its goals? To establish 2 lakh new impacts, that is multi-purpose primary agriculture credit society, means create bodies which will lend more to the cooperatives. All these are just goals, okay. And also they will want to bring about Tribhuvan Sahakari University, set up cooperative agricultural universities where specific training will be on cooperatives. All these are goals, not definitive things that has happened. So we have to wait and see if these are going to be getting created. We'll move ahead. So 2025, I've told you, is the year of cooperatives. UN has designated, and this will be done by your UN General Assembly. If you see what is the tagline, this is important for your upcoming prelims. Cooperatives build a better world is the title, and they are trying to integrate your cooperatives with UN Sustainable Development Goals. 2025 is year of cooperatives. The theme is cooperatives build a better world. Done? We'll move ahead. So I'll read out a question. You tell me it's correct. With reference to cooperative movement in India, consider the following statements. 97th Constitutional Amendment added Article 43B under DPSP. 97th Constitutional Amendment added 43B under your this is where it promoted states and it told states to promote cooperatives. The Ministry of Cooperation was established in 2021 to promote cooperative development. Correct. Ministry of Cooperation was created in 2021. Multi-state cooperative societies are regulated under a Central Act of 2002. That was the very first thing that they created. International Cooperative Alliance is headquartered in Geneva, Brussels. So 1, 2 and 3 are correct. Next topic is reforming centrally sponsored schemes. There are 2 types of schemes whenever government gives out. One is central. We are speaking this strictly from your central government perspective. Central sponsored schemes and central sector schemes. These are the 2 types of schemes from your center. Write this down. Central sponsored scheme and central sector scheme. Okay, listen to this. This 2 to 3 differences are very important for this. Whenever I tell central sector schemes, 100% of funding is by center only. Okay. When I tell central sponsored schemes, there is a division between center and state. Now when I tell division between center and state, certain states के लिए, for example normal states, it will be 60 to 40 pattern. Center will put 60% of money, state will put 40% of money. Okay, this is for normal states. Now let's say it is Himalayan states, Jammu and Kashmir, northeastern states. The ratio will be 90:10. Himalayan states, northeastern states and your Jammu and Kashmir. Now if it is a union territory, mandatory, then 100% of funding is by your center only. Okay, one important difference is central sector 100% central government funding, whereas in central sponsored the percentage will vary. Sometimes for many schemes it will be not just 60-40 but also 75-25 also will be there, 80-20 will also be there. Okay, if this is one crucial important difference, second one is all the things that is coming under central sector schemes are the topics in union list. This most times you might forget it. All the schemes that come under central sector schemes are the topics which are there in union list. For the topics that is coming in centrally sponsored, all the topics are your state list and concurrent list. Okay, see one example I'll tell you. State list pay if topic is there, then only state can make a law. Yes, center cannot make a law on that. Let's take one example, health. Health is a state list concept, but center spends so much of its money on trying to provide healthcare for people. How? It is through this only, central sponsored scheme. Why means your states already have limited resources, they don't have adequate money to do everything on their own, so we have to supplement money for them. Understanding? In this case, what the center will do means whatever money it is to give 60% or 90% or 100%, it will transfer it to the state consolidated fund. You all know consolidated fund of state is there. They will transfer it off for the respective states. In this case, they will not transfer any money to state, they themselves are implementing, no? So they will create their own bodies, they will only implement the scheme. Now the issue what has happened means, center will usually send money to the states. Okay, let's say one example is your Pradhan Mantri Jan Arogya scheme. This is actually something about health. I told you healthcare is in state list. Now your center will send the money for each of their state to their respective bank account. Here that is consolidated fund of state. With that money the state should spend. But there is one condition. State whatever money it has got, it should spend only for this particular scheme if they have given money. Okay. The issue started was CAG, your Comptroller and Auditor General is there. No, he was observing one trend. Pura year pe they are not spending. When the money is full in bulk or when it is nearby the end, that time one time only everything they are spending off. Why should they spend like that? Because there is opacity, there is opaqueness, no transparency as to how much money center gave, how much money state is spending, for what is it spending. One example I'll tell you, midday meal scheme. In order to promote midday meal scheme, government is sending money to states. But each state is putting one rate. Cooking cost in my state is this much, cooking cost in another state is this much. So there are different arbitrary rules. Because of this, there is no transparency only. Why this topic we are discussing means CAG has told, Comptroller and Auditor General of India has told, I will set up a committee who will tell how better can you spend money according to the central sponsored schemes. Okay, this is why we are discussing the topic. Done? So why is it news? CAG formed a committee to reform centrally sponsored schemes. Centrally sponsored schemes means they are funded by both center and state. The topics will be in both state and concurrent list. They will give the fund to state consolidated fund. As of now, we have 54 central sector schemes and per 1 rupee pe 8 paisa is spent in the center to your central sector scheme only. Roughly around 10% of the union budget they will spend it on your centrally sponsored schemes. Again, the ratio, like I told you, Himalayan states are 90-10, normal states are 60-40. If you see the categories of central sector schemes, there are certain schemes which are core of the core where you cannot stop the funding for that. It is very important to continue the funding. One such is your social protection and inclusion schemes. Example, your Manrega schemes. Other schemes are like your development schemes, that is Pradhan Mantri Gram Sadak Yojana, midday meal scheme, National Health Mission. Okay. Then comes schemes which will be applicable only for few states. Border area development program. If you are mainland, you don't have border with any other countries, why will that scheme be applicable for you? Okay. Shall we move ahead? So, we have seen this central sector scheme, 100% your center, sponsored scheme is center and state. Implementation of central sector scheme is completely by central government, here is by respective state governments. All the topics are under union list, here it is under state or concurrent list. No fund is transferred in a central sector scheme to states, directly they will only implement. Here they will transfer it to the states to their respective consolidated fund. These are of national importance, for example, your space research, atomic research, your BharatNet, all these will come under your central sector schemes. Your Manrega, National Health Mission, Pradhan Mantri Gram Sadak Yojana, all these will come under your central sponsored schemes. Okay. Because we brought in about CAG, let's see some points about that. CAG is constituted according to Article 148. CAG, Comptroller and Auditor General, is appointed by the President of India. Term is for 6 years or 65 years. After once they serve as CAG, they are not eligible for further reappointment in the Government of India. Also, there are something called as key pillars in a constitution. That is, we have 4 key pillars. These are the main things that will run the constitution. What are those means? Election Commission, UPSC, CAG, what is it? Supreme Court. Election Commission, UPSC, Comptroller and Auditor General, and then is your Judiciary. Okay. A CAG is given security of tenure, which means a CAG can only be removed on the same grounds as that of you remove a Supreme Court judge. How is it? Proved misbehavior or incapacity, which means again same 2/3 of the members present voting, all that strict things will apply here also. What is the key role of your CAG? He will ensure legality, economic prosperity, that is whatever money they have told, have they spent it for that. But the word is Comptroller and Auditor General. In India, the CAG does not do the role of Comptroller. Comptroller means before you take the money, it is seen in UK, Britain, where they have to countersign telling okay, you can take the money. Here no such Comptroller work is there. Only auditor work is there. Even though they are called Comptroller and Auditor General, they do not perform the role of your Comptroller. 2025 का मेंस क्वेश्चन एंड 24 पे also they have asked about your CAG duties, powers and conditions act of 1971. This is the act that gives power to your CAG, that is legislative powers. So as of now, what are the issues that we see with your central sponsored schemes? Opaque budgeting, irregular fund flow, inflexibility, payment delay, weak auditing and monitoring. No need to write this down, this is what we discussed. So I'll read out a question on this, you tell me whether it is correct or wrong. Which of the following statements regarding centrally sponsored scheme are correct? They are fully funded and implemented by central government. Which is fully funded and implemented by central government? Very good. Central sector schemes. This is not fully funded. This is both center and state funded. The percentage may differ. Funds under CSS are routed through consolidated fund of state. That is how they are sending it to the states. CSS primarily focus on subjects under state and concurrent list. This is also correct. Okay. So 2 and 3 only. Next topic. Not just PMLA or UAPA, give reasons for arrest in all offences. This is the recent 2025 verdict of judiciary. Done? First and foremost, this is a very important decision and the possibility of this coming in your prelim statement question is higher. So, understand two things. There are some special laws like PMLA or UAP. Prevention of Money Laundering Act 2002, Unlawful Activities Prevention Act of 1967. In these respective acts, again one more act will also come, NIA Act. I'll tell that little bit later. Wherein if you are going to arrest someone or detain someone under these laws, they told you have to give a written consent for it. That is, if police are going to come and arrest you, unlike in movies tell arrest that fellow and bring, they have to physically give you a written document stating why you were arrested, on what grounds you were arrested. This is for special laws like this. Okay. Now recently what your judiciary, specifically your Supreme Court, told was, not just for these two you have to tell the person you are arresting him for what, even for normal offences you have to tell them, let's say before 2 hours, let's say you are going to detain him, and that is the issue of very important national security, also means even 2 hours before you produce him, you have to tell him the reason as to why he is arrested or detained. This is a very important thing, especially under Article 21, right to life, and also your personal liberty, which will also be under your Article 22. So, the recent judgment, write on the exact word, mandates that reason for arrest must be communicated at least 2 hours before production for remand. 2025 judgment mandates that reasons for arrest must be communicated at least 2 hours, must be communicated at least 2 hours before production for remand. So they are telling, if you don't do that, your Article 21, right to life and personal liberty, and also Article 22 of 1, right to be informed of reasons of arrest and to consult a lawyer, as well as Article 22 of 2, wherein you have to be produced within in front of a magistrate within 24 hours of arrest. All these three will get violated. Okay. So which are the articles at stake here? Article 21, Article 22 of 1, Article 22 of 2. If you see what are the provisions, that is legal frameworks that we have in order to arrest a person or follow the procedure how you have to arrest. One is your IPC, Indian Penal Code, but recently it is called as Bharatiya Nyaya Sanhita. Another is your Criminal Procedure Code, otherwise called as Bharatiya Nagarik Suraksha Sanhita. Okay, these two are mentioning the procedure to be followed when you are going to arrest a person. Done? Shall we move ahead? So, special acts I told you, Prevention of Money Laundering Act. In your Pankaj Bansal versus Union of India in 2023, they told you have to give them in written writing as to why you are arresting them. No need to write this down. Same under your UAPA also in 1967, they told whenever your National Investigative Agency is going to arrest anyone, they also have to tell the people on what grounds they are going to be arresting them. Now, judiciary told that not just for UAPA or your PMLA, for even any normal arrest also you should tell the grounds for which you are arresting them. So, this applies to all arrests, and with 2 hours before you send a remand you should tell them, because this is a constitutional right that protects Article 21, 22 of 1 and 22 of 2. And they have also told that if you don't follow this procedure, that is for all the arrests you have made, if you have not told them the ground for their arrest, then your arrest itself will be held as illegal detention and we will let them go free. Okay, so there is a punishment also if they don't do this. Failure to communicate the grounds of arrest will lead to illegal detention. Done? So these are all the judicial observations where they tell that personal liberty cannot be a hollow formality. All arrest reasons must be recorded and conveyed to the person. Or it will apply to everyone in all the situation, because Article 14 is equality, right? So it makes sure when we do this, everyone are treated equally under the law. Now we have a list of cases where what and all they had come up with, not very important, you don't have to write down. In Joginder Kumar versus State of UP in 1994, they said that all arrest must have a justification as to why are you arresting him. Simply you shouldn't go and arrest someone. In DK Basu versus State of West Bengal in 1997, they held that if you have to arrest someone or detain someone, you have to follow particular guidelines or procedure. In Arnesh Kumar versus State of Bihar in 2014, they said that you have to record the reasons before you arrest a person for minor and petty offences. Understanding? And more than 77% of cases which is being arrested are on these, where a person can be sentenced up to 7 years in prison. Pankaj Bansal versus of Union of India in 2023 held that you have to give written grounds as to, you have to give a written document telling why are you arresting a person under Prevention of Money Laundering Act. November 2025 they have held that you have to mandatorily disclose what grounds you are arresting a person, and this is for all cases. Okay, now I will read out the question on this, you tell me if it is correct or wrong. With reference to Supreme Court judgments, consider the following question. The Constitution requires that every person arrested must be informed on the reasons of the arrest. 21, 22, 1, 22, 2 all state the same thing. So this is correct. This requirement applies only to special laws such as PMLA and UAPA. They told all, not just these but to all. So this is wrong. Failure to furnish the arrest grounds may tender the detention unconstitutional. Yes, they have to scare them to doing it, otherwise this will happen. So correct is 1 and 3 only. Last topic, Supreme Court to review on surrogacy ban in couples with one child. Done? See, concept is simple. In our country, there is a strict rule that only altruistic surrogacy is allowed and not commercial surrogacy. Altruistic means this is non-commercial. You can't pay to people to be a surrogate. Okay, that is when they can't conceive naturally, their particular DNA or all that mixing sperm and your egg are fertilized and placed in a womb of another woman. Now this they are not allowing. Your Bangladesh pay, there is a severe strict which is only for commercial surrogacy. Your Indian government has one of the toughest laws with regarding to surrogacy, which tells that we will not allow for commercial surrogacy, because this would mean that the right to life of poor people, especially a poor woman, would be completely violated, and a person's economic status would further detain her health. That is, her health will be further deteriorated because of multiple pregnancies. Okay. Now what has happened means, let's say a particular couple has one child. Okay, one living child is there, and there is something called as second child infertility. This is a common concept which affects many people. Almost 10% of the population get affected by this throughout the worldwide. They have conceived one child, but they will not be able to conceive the second child. Your let's say according to India's laws which are there, if you have one living child, you cannot opt for surrogacy. The first child may be your biological child, or that child was also gotten through your surrogacy, or if it was even adopted child also, you cannot go for a second child surrogacy while you have a living child. Now what your people that is advocates or petitioners are arguing means, do we have any rule that one family only one child should be there? Why are you telling that second child should not be done? When parents are not able to conceive a second child, it is the same amount of pain that they faced when they were not able to conceive the first child. Now this matter went in front of Supreme Court. Here the person dealing with this is your Justice Nagaratna. Okay, that person has now told that this is not just a yes or no kind of situation. We have to deal with fine nuances of this case. And studying this is so far what has happened. So Supreme Court in November 2025, that is recently, it has told that it will review the section 4(3)(c)(2) of Surrogacy Regulation Act. This is the section that tells that if you have one living child, you cannot go for surrogacy. If you have one living child which is physically disabled or mentally disabled, or it is diagnosed with a grave illness, then you can go for surrogacy for the next child. In only that one exception, you can go for surrogacy with existing child, but otherwise you can't go. So judiciary has told that we will review this. They have not yet given out a verdict yet. Okay. According to Surrogacy Regulation Act of 2021, married couple with one living child, even altruistic surrogacy, that is in their own members itself, they cannot have any form of surrogacy, they cannot have. Okay, the petitioners are claiming that this violates Article 21. First and foremost, we will see about your Surrogacy Act of 2021, the Act. First and foremost, it tells that we have only altruistic surrogacy. Okay, which means only your close family members will be there. You cannot specifically hire someone to be your surrogate. and you will only pay for their medical expenses, whatever happens. And commercial surrogacy is completely banned in India. Okay. If you have to be surrogate for the very first time itself, there are some conditions. Only married couples who are 5+ years married, and in all the 5 years they have to be trying for the child, and in that they are infertile means, then only they can go for a surrogacy. And if they already have any surviving child, they can't go for second surrogacy. Exception is if the child is mentally, physically challenged, or a grave disease has been identified, that is life-threatening disease. Alongside the same Surrogacy Act has also given effect for ART, Assisted Reproductive Technology Act of 2021, that is your IVFs and all. Basically what central government is telling is, if a person has exhausted all possibles of trying to conceive a child, then last option only should be for this, not as the very first option. Secondary infertility, okay, it affects, according to World Health Organization, 10 to 15% of the couples globally it is affected, where they are unable to conceive the second child even though they have conceived the first child. Okay. Center is telling there is no fundamental right to surrogacy, so you cannot ask for us to compulsorily give you this surrogacy procedure. And another thing, Article 21 is right to life. Your right to life does not mean you will take someone else's right to life. That poor surrogate woman who, because of her economic condition, is trying to do this. She may not know this. Presently she is just trying to make some money for XYZ reasons. But what will happen to her body, her state after multiple pregnancies? Whereas they are also telling that through this ban, we are trying to prevent commercialization, we are trying to protect the surrogate mothers, and also avoiding the misuse for non-essential pregnancies. That is, the whole point you took surrogacy is you don't have a child. You already now have a child. Why do you want one more child? This is where the petitioners are arguing. Why are you telling only one child should be there? There is no such rule in India that one child, one parent. So they are arguing that right to reproductive choice is part of personal liberty. And India has no one child policy. Then why are you restricting this? And they are also telling that secondary infertility is a legitimate medical condition, so give them the right for a second child also through surrogacy. Supreme Court on this has held that, see, it is true that there are matters about privacy and also reproductive autonomy. Simply we cannot tell yes or no for this. We will review this and we will come up with a solution. Okay, this is what they have told. And also they have even told that India's demographic profile does not justify one child restriction. Once you have a child doesn't mean you shouldn't go and have one more child. Like your China had 2-child policy, 1-child policy, those kind of things is not there for India. So we don't have the need for that. But we are also seeing that what center told is also correct. We will look into that. That is what they have told. So reproductive choice under Article 21 in Suchitra Srivastava case or your Justice Puttaswamy case, they told right to procreate and family planning is also under the family's right of self-determination. Under Article 14, blanket ban, that is telling no first child if you have gone through, you have a living child means you cannot go at all for a second child, is a blanket ban. With respect to Justice Puttaswamy case, right to privacy when it was added under Article 21, this also protects decision in personal life choices. If you want 2 child, you can have 2 child. And state can put reasonable restrictions, that is also there, so as to make sure exploitation of poor mothers will not happen. So I'll read out the questions, you tell me which is correct. Consider the following statements regarding Surrogacy Regulation Act of 2021. The Act allows commercial surrogacy under strict medical supervision. We do not have any form of commercial surrogacy, that is completely banned in India. A couple with one living child is not eligible for surrogacy unless the child is mentally or physically challenged. Correct. The Act permits altruistic surrogacy only for Indian married couples. Correct. See, unless and until you are Indian, the law is not applicable for you. And it is only for married couples, not any couples with living relationship or any couples who are single parents. Understanding? So this is correct. Only 2 and 3 are correct. Clear up until here? This completes today's current affairs session. Any doubts? Online class, any doubts? We'll end the session.
Record.
Thank you, class.